This man, Timothy Foster, he's sitting on death row in Georgia as we speak. He was convicted of killing a white woman back in 1987. But the Supreme Court just ruled that prosecutors violated his constitutional rights because they intentionally picked an all-white jury. Now, the name of each potential black juror was highlighted in 4 different copies of the jury list, and the word black was circled next to the race question on those questionnaires. Now, 3 of the prospective black jurors were identified in notes as B number 1, B number 2, B number 3. Now, Foster gets to seek a new trial. Okay, I want to ask some questions on how the rules work, and then I want to get into the reality of it. Peremptory challenges, which is basically your get out of jail free card, or a bad example, I guess, the expression. But you can use that whenever you want for no reason and just say, no, I want to take this. How many do you get a trial?
Well, it depends on the nature of the case. It depends on what level felony it is, or if it's a misdemeanor. So it can range.
From?
Gee, I guess on
homicides are 20.
Yeah.
Class A felonies are 20. Class B felonies are 15. Class C felonies are also 15.
And yeah.
Okay, so before every trial that you've had, and as people know, both you guys have been on both sides, former assistant prosecutors and also now defense attorneys. Do you have in your head, with all the experience you have, before the advent of Google, where you can look up the jurors in real time, do you have in your mind, okay, likelihood, without certainty, this person, whether male, female, black, white, old, young, line of work, whatever, this is going to give me my best chance for a conviction or acquittal, depending it. Do you know that, where you're looking for a certain kind of juror? Let's say you're a prosecutor, put your prosecutor hat. You need that conviction here. Are you looking first and foremost for people you don't want on the jury rather than ones you do?
Generally, as a prosecutor, if I have a good case, and hopefully I have a good case or we're not going to trial, I want people who are really going to seek the truth. They're going to listen carefully, because ideally the truth is going to bring you to a conviction. On the defense side, I also want people who are going to be thoughtful, because they're going to see the nuances in the case. They're going to listen to whether someone's credible. They're going to pay attention.
Okay,
they're not
put
going
your
to come in.
prosecutor hat on. I'm not letting you off that easy. If you see that somebody from the ACLU is potentially there, you're going to say, hopefully I can get him kicked when the judge agrees, or I'm using a peremptory challenge, because the chances of this person looking for an acquittal are much higher than some guy who's, fill in the blank at X Union.
Well, normally, sure. As prosecutors, they always want people from Con Ed. They always wanted people who work for the telephone company, because the prevailing wisdom was those people would be more conservative, more likely to convict, more favorable to police. But it comes and goes, and it changes, and it depends on what kind of cases are in the news. Because I remember as a prosecutor trying cases, and Rodney King had just occurred. So it was much more difficult for all police, and you could have the best officers in the world, and the jury was going to be skeptical of those people. And sometimes prosecutors do things like they strike African-American jurors, and they make a mistake, because maybe you would have had Clarence Thomas on your jury, and he probably would find that your client is guilty. So.
Yeah, but there's no question that, right now, with all that's going on in the news, that defense attorneys are going to be looking for minorities in cases where you have a police case and so on and so forth. And nobody can tell you that it doesn't enter your mind. But you go in, Rich, with some broad outlines. But in state court, where you get to question the jurors, you'd be surprised. You need to talk to all of them, and you get a sense of who is biased toward one side or another. And many times, there'll be white jurors that are the fairest you'll ever find, and perhaps minority jurors that are not with you. You go in with certain guidelines.
Give me an idea of a question, Jimmy, that might surprise the audience, that you'll ask of prospective jurors to get an idea where their head's at.
What I like to do is I actually look for jurors I don't want, because then you can use that juror to educate the rest of the jury. So I'll ask jurors, would you have a problem if my client didn't testify? At the end of the government's case, you're not convinced beyond a reasonable doubt. There are answers to questions. You want those, and obviously my client is the best person to answer them. But he doesn't have to testify. Would you be okay with that? Would you hold it against him? And you'll be surprised how many people say, I would. If you didn't do it, tell me you didn't do it.
Is what happened in the particular case that I just described noteworthy to you guys because, Mayo, it happened or because these guys wrote it down? Is this happening in courthouses across America, except people don't say B1, B2, B3?
Oh, they do. And sometimes even, I mean, there have been prosecutors who will write down victim is white, defendant is black as charged, and that's noted in a file someplace. You know, so that happens all the time. The biggest issue I always find, to Jimmy's point, is it's not necessarily what your race is, because you may have an African-American person and the defendant's African-American, and she may be or he may be more biased against the defendant because they live in an area where more things occur, you know, or you may be in a situation where you have people who just don't understand the law. Normally, I want to find at least one person who's going to be a leader, who's going to be thoughtful, who understands the burdens and is not going to let it shift. Because most of the time, after the judge gets finished saying, you know, you're presumed innocent until proven guilty, by the time we ask these people, well, you think they must have done something to be here with us, you have 12 hands that go up.
In a major felony case here, of the 20 peremptory challenges that the prosecution and defense has, on average, do most of them get used or not?
You know, it's an interesting thing. That probably speaks most to the art of jury selection, because who's got how many perempts at the end of each round is huge. And so that's why you have to do as incisive of voir dire, as we call it, as you can, because in homicides, most of the time they all get used. In lesser crimes, not as much. But I have to say one thing. The thing that troubles me the most about this man's been in jail for 29 years before the Supreme Court said that there was a Batson violation. There is something really, really troubling about that.
Well, but the thing that is positive here also is that we have a court that's divided so politically right now that we can't get that ninth justice. And they come down 7-1 that this should be undone. So a lot of times what we believe the court is going to do is erroneous. And the one person who votes in favor of
it's going to be, though, I would imagine, and I got to hit a break here, when it's not so obvious, hard to prove. You know,
they're very hard to prove.
Yeah,
they're very hard to prove.
Okay, coming up next, when it comes to insider trading, I think most of us would think we know what it looks like, we know what it feels like, we know what it does. But I'll tell you, the law is they're inside out. People can make a lot of money using inside tips, but still not get charged even when the feds know about it. That's what happened to pro golfer Phil Mickelson. His story straight ahead.